Are you looking to protect your property after you die? Are you also concerned with how your property will be distributed after the fact of death? Join us today as we discuss the legal process of distribution of your property after death. Welcome to the show. I am your host, Mercy Wanza. Today we talk about a rather touchy subject, well, at least in Africa, and that has to do with death. How do we legally prepare for death? And today we are joined by an advocate of the High Court who goes by the name Mr. George, who will tell us more about how we legally prepare for death. Welcome to our show, George.
Thank you very much.
Do you want to tell us more about yourself?
My name is George King. I'm an advocate of the High Court of Kenya. I practice in my own farm in town. I'm also an entertainer. I go by the name of King George Gustavo, and that is what I do after hours.
Right.
Yes.
So tell us, in trying to demystify what, or rather the legal process after death, what is a will and what is contained in it?
Yes, a will is a written document by an individual who wishes to declare his wishes after he has passed on. So you write down your intentions of how your property will be safeguarded or how your property will be distributed once you pass on, and how you wish that to happen. It is a legal document. It is safeguarded by the Law of Succession Act. So what you will contain in a will is a declaration of all your property, a declaration of how your property you want your property to be divided among your children, your wife or wives, for those who have many wives, and any other person that you think will benefit from your property once you're gone. The will also has to get validity, so it has to be properly signed by the person who's creating the will, and it has to be witnessed by at least 2 people, and that validates the will. Inside the will, you can also have gifts, how you want to issue gifts to some of your members. There are people who give property to charity. That can also be contained in a will.
Right.
Yes.
Now, maybe you need to also tell us who writes the will. Should it be me who wants my property to be distributed, or someone else can do it on my behalf?
Well, what happens is most people go to lawyers, and in conjunction with the lawyer, you will come up with a draft will. And you will give the lawyer the information that he requires. Obviously, the lawyer will put it in a form that is legally sound, and a form that will be allowed by a court. Yeah.
Now, who is a guardian in a will? Can you tell us more about a guardian?
A guardian is usually when you pass on, most people would leave children, and those children would have to be in the care or in the guardianship of an individual. And that is the individual who we refer to as a guardian in the will. And the will also have executors. Executors are the people who will ensure that the will has been, the wishes of the person who has passed on have been fulfilled to the letter. So once you document everything that you want to put in a will, that is the property that you have, then you will assign an executor who will now execute your wishes in accordance with the will.
So, say for example, I have property, either it is land or just something that I need to pass on, or rather to be distributed, as you have said.
Yeah.
Why is it important for me to ensure that that is distributed? Why can't I just stay and not have it distributed? Why is it important?
Fine. In the African setting, and we have seen this in very many instances, there has always been a lot of squabbles once a person passes on, especially individuals who are high net worth. So you will find instances where the family will fight for years on end. Now, a will reduces that risk first and foremost. So the individual will document each and every property that he owns, and he will assign each and every property to a beneficiary. That will reduce the trouble of a prorated succession in court, and it will give the court a clear indication of your wishes while you were still alive. So that is the first main reason why we need to do the will.
Okay. Now we understand that it's important to have a will. Now, assuming that I have written my will and I die, what is the legal process that follows that?
Okay. So first and foremost, your family will be issued with a death certificate from the Civil Registrations Department. Now, with the notification of death or the death certificate, that document together with the will I would propose that you give it to a succession lawyer.
Right.
So the succession lawyer will file for a succession proceedings in the court of law. Now, what happens is after the process has gone the whole length, you will be issued with a grant of probate. A grant of probate is a declaration by the court that this property should be divided in accordance with the will of Mr. X.
Right.
So once the family or the executor has been issued with that grant of probate, it will be gazetted for 6 months. In these 6 months, anybody who has an objection will have a right to come to court and file that objection. If there is no objection, and after 6 months, you will have to go back to court to get what we call a confirmation of the grant of probate. After that, you are now allowed to distribute property in accordance with the grant of property. So if Mr. X left a house to his wife, then the wife will get the property at that point.
Very interesting. Now, assuming that I had written a will, but I've bought more property and I wish to change the will to be able to reflect the new property, is it possible for me to change the will?
Yes, a will is not cast in stone. You can change the will anytime. What a lawyer would advise you to do is add what we like to call an addendum or a codicy. But most lawyers will advise that you totally do away with the first one.
Okay.
And write a fresh will. Also, I have to point out to the viewers that if you marry after writing a will, the will automatically becomes void. So you have to provide for this new dependent.
Very interesting. Now that means that the previous will is totally done away with, and I have to rewrite my will.
You have to rewrite a will.
Very interesting. Now, just as we come to the very end and as we wrap up, tell us about contesting of a will. Is it possible that once, for example, my father has written a will and I'm not satisfied with it, that I can contest it?
Yes. A will is supposed to provide for dependents. And there are instances where a dependent will feel that they have not been, either they have been left out totally, or they have not been provided for sufficiently. So the defendants have a right to go to court and object. And you will remember there's a 6-month period where they have an opportunity or a window to go to court and file those objections. Now the court will listen to the objections and the court will get evidence and it will make a decision at the end of the day. So indeed, you can contest the will if you feel that you've not been sufficiently provided for.
Okay. Yeah. So you say that someone has the right to contest, but do you have a right to be in the will?
Dependents need to be in the will.
Who are dependents?
So dependents are wife and children and people who depend on the individual who has just written the will. So we have family, we have mother, father, some brothers, but then this will be decided by the court.
Right.
Yeah.
This has been very informative. We have come to the end of our show. Many thanks for watching. King, thank you for coming to our show.
Thank you for having me.
Absolutely. We have come to the end of yet another episode. Many thanks for watching. For more information, log on to our website on www.wakilimkononi.co.ke. You can also follow us on our social media pages on Facebook, Twitter, or Instagram at Wakilimkononi. Remember, ignorance of the law is no defense. Until next time, bye.